now. It's in Ray Adoption SGL. The case was set for 12 o'clock. My understanding is the appellant is here to argue but just arrived. Our procedure is that you have to arrive during the time period that you're set to argue, because we can't have people just showing up anytime. But what the court is going to do in the interest of justice is give you 5 minutes to present your argument, if you'd like to do that.
Yeah.
Okay, all right. So you will have 5 minutes.
Okay.
Thank you. And don't mention the names of any victims, don't mention any minors. Please, we are recording this and it'll be on YouTube, so just refer to people as, the child or,
Okay.
or by initials or something like that, okay?
I do apologize about being late. I did try to call in, and we didn't.
And they alerted me, it's just a matter of, I can't treat you any differently than I do anybody else, that's all, I'm sorry.
No, that's okay.
Thank you. But we are extending you a courtesy.
I do appreciate it. It's no problem. Let me just figure out what I'm doing. So,
Okay.
Okay, fast forward to the adoption hearing. I guess I feel that the judge erred throughout the case was several things. One of the first things that he did not do is take any of our evidence into consideration. If you see in his decision, none of the stuff that we presented to him did he even consider, towards. He believed, unfortunately, the plaintiff as far as some things on my account, as far as they're saying it was personal items on my business account. It was not. It was office supplies. The flowers went to a vendor in Arizona as a thank you, and some other stuff. But the judge, took those few items and made it seem like I had all this money to spend.
Now, I don't remember right now, but did you present evidence as to what that $29,000 that you withdrew was actually spent on? Did you testify or did you present any documents?
The biggest thing with that is I work with my hands. I'm horrible with books. I'm not that good. I hired an accountant for all those years. He takes care of everything that happens there, he takes care of. We subpoenaed him to court that day. He has all my records, he had all my receipts, he had everything I needed to file or to show the courts. He was a no-show. And as it turns out, he thought that it was a setup because he got in trouble for embezzling, and he took some of my money too, but that's never us. So he never showed up for court. So I was dead in the water. So I tried to explain the stuff the best I could with what I knew. And so that was that. But regardless, another important piece is that she did get paid, and all the claims of non-child support and all that, that's bogus, because when we got divorced, she got a lump sum of money for almost $30,000. They should cut her up until my child was 7. The judge failed to put it on my books. That's why I was trying so hard to get my records so I could show that. The only way I could show that is to get my records that court is withholding. So that being said, all the other stuff that they were saying about my account was speculation. There was no soundproof that they didn't bring anything soundproof that I had money to spend. Just because those numbers are that big in my account doesn't mean that's money for a business to spend. GM had $1 million in the bank account when they filed for bankruptcy. It doesn't mean they had $1 million to go spend. Same with my company. Just because there was big numbers in there that they thought, oh, here's these big numbers, he's got money. No, it's not. That year, I filed for unemployment. I had shut-off notices. I was being sued by another bank for failure to pay. I sold my personal truck. I showed all this stuff to the judge, and all they
You
had.
testified to that?
Oh yeah, I gave him all the stuff.
Okay, and we'll be able to read the transcript. I was just wondering today.
Okay, and they didn't. All they had to show was my business bank account with speculation. That's all they showed, and I brought in everything to show I was on unemployment, and that Judge Stevenson that same week. I gave him about a third of the paperwork to approve me because in domestic, that same week I had he approved me for a public defender because I could not afford a lawyer in domestic. He gave me he found me indigent that same week. So how can I be found
you have a child support contempt action
I did, at the same time that this was going
that
on.
I presided over at domestic?
You didn't preside over it, but Joe Gilletto said that the paperwork is going to you for approval of a public defender.
Okay.
So I provided my financial information to show you I was belly up. This same week, I was in there, so how come one court could tell me I'm belly up, and you could easily see that I was stuck, and this court is telling me I had money to spend. I brought in, and also that at the same time was the unemployment. The government allowed for self-employed people to get unemployment, and that is never heard of.
During
When you're-
COVID.
Yeah, when you're you can't get it. But during that time, they allowed for it. The stack of paperwork I had to turn in to show I needed that money it took me months to get approved. And so if the U.S. government can tell me, yes, we find him that he needed help, how come probate court couldn't see that I needed help? Also, I filed a motion to tell Judge Joe before any of this happened that I needed, that was changing my situation. I tried to get in front of him. He ignored every single motion, as you know. He ignored 10 of my last motions. There's nothing I can do. I tried to get in front of the judge. He wouldn't see me. So,
Counsel, I apologize, I'm so used to
good,
saying
I'm not
counsel.
kidding.
Your 5 minutes is up, but what I'm also gonna allow you is a minute to rebut anything that they have, that they want.
Okay, thank you so much.
Okay, thank you.
May it please the court, my name is Gary Rosen. I'm pleased to be here on behalf of the appellees, Your Honor, Marshall Lewis, who is the potential adoptive father in this matter. I think it is important for this court to have an overview of the facts, the basic facts of this case before we review the legal issues that are germane to this court's review today. SKL, the minor child, was born August 5 of 2014. That child is now 9 years old. Appellant and the mother were married and were divorced subsequently then in 2016. Mother remarried the appellee in 2020. On October 21st, 2021, appellee filed this petition for adoption of the minor child in Summit County Probate Court. And on March 25, 2022, a hearing was held before Magistrate George Wertz of Summit County Probate Court. A decision was then issued by the magistrate, and he found pursuant to his review of Ohio Revised Code Section 310707A that the requirements were met with regards to the key issues, which I'll review in just a moment. There were subsequent objections filed. Judge Stormer affirmed the magistrate's decision. An appropriate appeal was then filed. At the hearing in probate court, it was determined that appellant did in fact have a judicial decree for support at the time of the relevant look-back time period, which was October 21, 2020 until October 21, 2022, 2020 to 2021, excuse me. The support obligation was $638.33. Facts also adduced at hearing determined that appellant at time of the relevant time period, the 1-year time period, operated 3 businesses. First business being Master Tech Auto, and then 2 businesses which were non-operating defunct companies. At the time of the hearing, he owned a home, free and clear of any obligation, that he had paid cash for in the amount of $200,000. And that he had cash flow from his business.
Do you know when he bought the house? Was that in the record?
It was not part of the record as to when, I believe, and I have, it is part of the record, although the deed information from the Summit County Auditor's Office is part of the exhibits, and that will be Exhibit 14 in the docket. That's the records from the Summit County Fiscal Office. It's not mentioned specifically in the transcript, but it'll be noted, I believe, in the exhibit that was used for it.
More technically though, that was the business property, right? The home was owned by the business.
Your Honor, I would disagree with that, and here's why. At testimony during the trial, and the page references in the in the transcript I will give you with regards to the real property. It was not the property that was being used for the business, Your Honor. It was this was a home. The street name was Cayugas, and it is in the Portage Lakes area. The business is located at a different address in the city of Akron. This property, and the references on the transcript are pages 27 and 140, was purchased as a residence. It's not being used by the business, but it was purchased under the name of one of the shell companies. I mentioned just a moment ago, Your Honor, that at the time, the relevant time period, appellant had 3 business entities. 2 of them were defunct. Summit Towing was the entity that quote-unquote purchased the home. Summit Towing does not operate as a business. It was only used as an entity to purchase the home. Conveniently, because then it cannot be used as an asset for judgment purposes. Because also at hearing, noting what, again, the facts that used at hearing, it was also noted at the time of the hearing, appellant had $31,000 of child support arrears, and that no payment had been made, not just for the 1-year statutory time period, but dating back to April of 2019. So for 18 months before the statutory time period. So for 1 year before the COVID epidemic hit, no child support had been paid by appellant. 0.
Did the money obtained through the COVID exceptions go towards arrearages?
No, Your Honor.
Or what, was that just approved to go and it didn't, or?
Well, there's nothing in the record with regards to appellant receiving any funds from the federal government. And none of those funds were ever diverted to the Summit County Child Support Enforcement Agency for payment of support.
Well, is that in the record, that it wasn't diverted, or there's nothing in the record period about the funds?
The record reflects the CSEA records, Your Honor, and shows with a, what I'll call a printout from CSEA, that it was accurate and was authenticated by a CSEA witness that no payments were made from any source from April 2019 through the end of the statutory time period, which was October 21.
Right, but my understanding is that he received these funds, he applied, but did not receive the funds until after the hearing.
Well, obviously, there's no mention of that in the record as to when he would have received the funds, because
But
the
was it
record.
Discussed or anything?
Appellant, you'll see in the transcript that appellant indicates that he applied for funds.
Okay.
Obviously, the record is only going to reflect what occurred through that time period.
I'm sorry, I'd forgotten that. It just came up whenever you were answering my question.
Yes. So in answer to Judge Lansing's question, the CSEA records presented it as part of the transcript, and you will see as Exhibit 2, as part of the packet from Summit County Probate Court, reflect 0 payments from April 2019 through and continuing past the statutory time period.
But he raised the issue through his objections, or how did he raise the issue?
Appellant, you'll see in the trial transcript, noted that he expected to receive some funds, had hoped to receive the funds at some point, but he obviously did not receive them prior to the hearing. Now, understand the hearing was in March 2022. Statutory time period for this adoption for the 310707 look back was October 2020, October 2021. Hearing was then held 5 months after the look back period.
I'm aware of that.
Yeah.
I was just asking in regard to the objections that he filed. In the objections, did he mention that he had received the unemployment compensation and asked for it to be considered as new evidence?
I don't recall, Your Honor.
I think he said that in the brief, but we'll obviously know by looking in the record. We'll go through it all.
Your Honor, yes, I don't recall. I know that whether or not that was mentioned by appellant, you'll have to ask appellant that question when he comes back for 1 minute. I guess is the best response.
Well, we'll look through the record too.
Thank you. I think it is important to note the analysis that was utilized by the court with regards to 310707A and how the court made that determination, and why we will suggest to you at the conclusion of this argument that the court's finding was appropriate and just based upon 310707A. First, as noted, there was in fact, and I think there was no dispute, a judicial decree for support. It is interesting to note, however, that the decree for support, the support obligation, was modified effective March 2020. That modification actually was issued by the court in July 2020, made retroactive to March 2020. And during the COVID epidemic, and during the time period, which was the look-back time period of October 2020 through October 2021, there were no modifications made to the child support obligation, which remained at $638.33 per month throughout that entire time period. As noted already in response to the questions, no payments had been made. So not only was support not paid for the statutory time period, it had not been paid anything at all, been paid for a year and a half before the statutory time period.
So during the actual hearing on whether or not consent was required,
Yes.
was it discussed by either side that there was a contempt of court filed against them for non-payment?
Yes, Your Honor, that was mentioned because that had happened on numerous occasions. There had been contempt of court actions.
Okay, what about this I can't even say the word now, indigency part, where he's saying I was indigent for purposes of DR court, but then it's held against me that I could pay my child support?
I do not recall that being in the transcript at all, Your Honor. I do not believe that any, certainly no affidavit of indigency, and I would note, Your Honor, that appellant was in fact represented by counsel at time of the adoption proceedings, and it was not an appointed counsel, it was a retained attorney that was present for the adoption hearing on March of 2022. With regards to the issue, and this court I'm sure is aware, that 310707A then requires an analysis as to whether or not there was justifiable cause for the non-payment of support. And let me review with the court the relevant issues as it relates to the analysis of justifiable cause. Appellant was throughout the entire time period working. He was not at home, he was not idle. He continuously worked during the statutory time period, and before and after. He had an ongoing business. Yes, as I noted earlier, he had two defunct businesses, one of whom was used as a shell company to purchase the home for approximately $200,000. But the business remained an ongoing entity during the statutory time period. There was continuous cash flow to the business. In calendar year 2021, the cash flow to the business was $173,000. The cash flow for the statutory time period was approximately $186,000. Cash was coming in and out of the business on a regular and ongoing basis during the statutory time period. The cash flow was additionally used for personal expenses, and the trial court noted that specifically. Examples were used, and you will see an exhibit as part of the packet, of $3,600 of DoorDash expenses during the statutory time period.
Of course, that's also during COVID when everybody was doing DoorDash, right?
Yes, Your Honor, perhaps, okay, and although I think, we're not digressing too much as to how we'll survive what I'll call high COVID, most of us were going and buying groceries and staying at home and getting groceries delivered to our car, and we're not necessarily having strange people come to our door all the time. Not to the tune of $3,600, and not when neither of us or any of us were failing to pay court-ordered obligations.
And this is Mr. Pambukis' testimony that he used this for personal expenses, or did the court make that determination based upon the bank statements and otherwise?
I believe, Your Honor, as you review the testimony in the transcript, appellant will suggest that all of that was work-related, that all of the DoorDash expenses were work-related. And there's a comment where the appellant said, well, yes, at some point I had to eat. Certainly the suggestion might be by appellant that, oh no, this was all necessary as part of my operating the business. I believe that the court found that to be less than credible, and I will suggest to this court that while all of us had to get through COVID, none of us likely spent $3,600 on DoorDash over the course of 12 months, nor used business accounts for purchase of football tickets, as noted in the magistrate's decision, or payments to a psychologist. The court found, and I believe appropriately so, that there is a lack of financial controls, and that's often what we see with a company that's owned individually by a person. But business and personal expenses were being paid out of the business account. Also significant for this court to note is that appellant had minimal living expenses. The home was owned free and clear, no mortgage. And in addition, appellant had assets, additional assets beyond the home. But he had, as noted in the transcript on page 80, the business owned 4 or 5 vehicles, free and clear, no debt. Any of those assets could be used to some extent to pay something beyond de minimis support.
Counsel, you're almost out of time. I just have one question.
Sure.
All we're looking at here is, because I think you went through the other part, is whether he paid support. It's not a matter of whether contact.
Correct, yes, yeah, the contact issue was set aside in trial, that's
Thank you.
absolutely
I
correct.
just wanted to double check that one.
Yes, that's correct. So, with all that, I believe that there is compelling evidence on the trial court level to support the finding that 310707A was met and that this adoption to be approved. Thank you.
Thank you. Mr. Pandukas, I'm going to let you have a minute
Thank you
just
so
to reply, okay?
I'm going to be honest with you, I don't know what to say.
Well,
He's so-
you don't
so-
have to say anything.
So far out of touch that it's so left field. We'll start off with Paul. I did have a lawyer that I paid for 3 years prior because their storytelling, if you two remember, which I thank you for this, they made up a bunch of small to take my son from me the first time, to find a way to take him from me. And you two, stopped them in their tracks. And that's why I had Paul still I paid him thousands of dollars prior to that, so he still owed me some time. So that's why he was fighting for me. He didn't. You can
Well,
ask him.
keep in mind, anything that's not brought up in the hearing or filed with the court, we can't
Yeah.
consider anyway.
Okay. No,
For you or for him.
I think it was known that he was there for free for me,
Okay.
to the judge. So that being said, he was still left over from a case, prior to that, appeal case prior to that. They pulled Ohio BMV records to show what cars they were trying to find what I had at the time. They didn't find one single car with my name on it or my business name on it. So where he's getting 5 cars all of a sudden, I don't know. The show I'd like to know because I need one, so.
Okay, and you need to wrap up.
Okay, so as you can tell, they don't have anything sound. Everything they have is just speculation. The DoorDash, 100%. That DoorDash is open to all my guys in the shop. We all use it. We're out of town constantly, so that's where a lot of it came from.
Well, we will look at the record, and
Please.
everything that's in the record, we will consider.
Okay.
Thank you very much.
All right.
Thank you. And I appreciate both sides being here today and making their presentations to the court. The court will review everything, make a written decision, and have it sent to both sides through the clerk of courts. And then also we release on the Supreme Court website electronically with an email copy. So
Thank you.
thank you.
Thank you.